Speaking of intake, what would you want somebody, a potential client, to bring to an intake to talk? I mean, are there any documents? When you initially talk to somebody, what does that look like?
Potential clients or someone who's going through a very difficult experience in the workplace, it's a nightmare that they're living through, and the story, the timeline, the facts, are potentially never ending. And our job is to help the client focus in on what are the potential legal claims that he or she might have, as opposed to just hearing, here's when I started my job, here's every single thing that happened to me to be in. To help sift through what is discriminatory, what are the hostile or adverse acts that you experienced. And so we really try to focus people in, and we do that with a very specific list of questions. And we ask them to bring, if they have any documents relevant to their employment, we typically ask them to bring those as well to review them. But what we do is we start with an intake form that we ask them to complete to better help them organize their thoughts. It helps them to see what are the types of, and here's a good example. Oftentimes we get calls and someone will say, I was wrongfully terminated. And that's a term of art. People tend to think that wrongful termination means I didn't like the reason I was fired and therefore my termination was wrongful. And under the law, that's not the case. If there was a legitimate reason for that, if you were frequently tardy, if insert the reason here, you can think of a number of examples why a company would lawfully terminate someone. And as long as it wasn't based on some of the area issues that we've talked about before, as long as it wasn't unlawful discrimination, then there's probably not a wrongful termination claim as such. Of course, on the union labor side, that's a different issue, where wrongful termination would be termination without a just cause or having violated progressive discipline. And that's based on a contract with the employer. Most employees in this country don't have a contract with their employer. They're deemed at-will employees, which means they could typically be fired for any legitimate reason that the business has, as long as it's not an unlawful reason. And so when we say wrongful termination, we're really saying unlawful termination.
Okay. Now, this intake form, is that something they would fill out at home, or would they come into the office and fill it out there? How does that work?
It depends. Typically, we like to have someone fill that out. And again, it helps them organize their documents. It helps them organize their thoughts so that we can have a more productive conversation. Sometimes just coming in cold to the person's factual situation isn't helpful, but we always try to be flexible. Oftentimes people don't have equal or easy access to computers. Oftentimes people don't have access to email. And so it's difficult for them to fill out a form. So it's on a case-by-case basis, but we typically want someone to fill out an intake form that helps them organize their thoughts and helps us have a clear understanding of why they believe that the termination was unlawful.
How do you get paid? What is the basis? And our viewers have been exposed to different kinds of payment, but tell me how your payment structure, not specifically, but broadly, how does it work?
James and Noland works on a contingency fee arrangement. And so we provide a free consultation and we go through an intake process with the potential client, discussing the possibility or whether or not that person might have a claim. And if our firm has the capacity to take a case on that we believe is meritorious or would be meritorious, we work on a contingency fee, which means we don't get paid unless we win by way of lawsuit or settlement. If you're able to go all the way to a jury trial and you're successful, you are also entitled to petition the court for your attorney's fees.
Okay, but
and that's recorded on sorry, Amy, go ahead.
You go.
And so those attorney's fees would be an hourly fee basis.
Okay, so the potential client is not paying you anything for the consultation. If they are able to, you think it's a good claim, a claim worth pursuing, they won't have to put anything out to you. They won't have to put anything out to you. I won't have to pay you anything until and even then, you will just be paid out of whatever you either settle for and or get attorney's fee for, and or get a jury verdict for.
Correct.
Okay, and I'm assuming there's things in employment law, there's experts in employment law, there's cost. I'm sure you're gonna have to take depositions, all those things. Those are costs that you would front. So, and then take out of whatever the settlement and or verdict ends up to be.
Correct. And so we would petition the court for reasonable costs and attorney's fees if we go to a trial.